Morning, Judge.
It is 9:16. I'm sure we're going to have some other people joining us as we move forward, but I'll just let them in as we go. Thank you all for being here this morning. We are streaming this on YouTube as well, so hopefully we'll get some awareness out as we move forward. Miss Harding with Hill Country Casa approached us about a week or so ago, maybe 2 weeks ago, and asked us if we would be willing to do a child abuse awareness and prevention month proclamation. And obviously, of course, we are. I wish I had thought of it earlier, but I'm glad that she did. And so thank you to Hill Country Casa for putting this on. I've seen several proclamations with Belong all over the state and some other places too. So we're happy to do this. We've done it before, but I'm glad that we're doing it again here in 2024. So with that, I'm going to go ahead and begin the proclamation so I can respect all of your time and we can start our docket on time. So this is a proclamation of child abuse awareness and prevention. Whereas in the fiscal year 2023, the Texas Department of Family and Protective Services confirmed 31,475 children in state custody due to child abuse or neglect, including 92 from the counties of Bandera, Kendall, Kerr. And whereas child abuse and neglect are serious problems affecting every segment of our community, and finding solutions requires input and action from everyone in our community. Whereas our children are our most valuable resources and will shape the future of Texas. And whereas child abuse can have a long-term psychological, emotional, and physical effect with lifelong consequences for victims. And whereas protective factors are conditions that reduce or eliminate risk and promote the social, emotional, and developmental well-being of children. And whereas effective child abuse prevention activities succeed because of the meaningful connections and partnerships created between child welfare, education, health, community, and faith-based organizations, businesses, and law enforcement agencies. And whereas communities must make every effort to promote programs and activities that benefit children and their families. And whereas we acknowledge that we must work together as a community to increase awareness about child abuse and to promote the social and emotional well-being of children and families in a safe, stable, nurturing environment. And whereas prevention remains the best defense for children and families. Whereas the impact of abuse and neglect has long-term personal, economic, and social costs, therefore hurting Texas's future. And whereas court-appointed special advocates, CASA volunteers, are assigned by the court to speak up for a child's best interest and to help ensure a child's voice is heard. And whereas every child in foster care deserves a CASA volunteer, and whereas 9,590 CASA volunteers spoke up for the best interest of 23,943 children, donating 361,517 hours of volunteer service in Texas last year. Whereas Hill Country Casa, Belong, foster parents, healthcare workers, teachers, and others work to ensure that children in our community have a safe and happy future. Now, therefore, I, Robert Falkenberg, Child Protection Court of South Texas Associate Judge, do hereby proclaim April 2024 as National Child Abuse Awareness and Prevention Month, and urge all citizens to recognize this month by dedicating ourselves to the task of improving the quality of life for all children and families. Thank you for all that you do, those of you that are here, and everybody who works within our system and our process. I appreciate you being here this morning, but more importantly, I appreciate everything that you do. If we don't say it every day, I know Miss Greenlee, Sheriff Greenlee, and I, my coordinator, we appreciate all of you and all the efforts that you put in for the children, not only in our counties, but all over the state and all over the nation. So thank you all so much for everything that you do. That will conclude our proclamation. I will leave this recording on our YouTube channel so you can share it with whoever you might want to share it with, and it'll just stay up there indefinitely. All right. Thank you. Have a good morning. Thank you. Have service yet? Is that correct?
We do actually, Your Honor, the 17th of April. It got returned this morning, but it's my understanding that Ms. Fuller, the mother's attorney, has not been able to make contact with the mother and is asking for a reset.
And how do you feel about that?
I don't think, well,
You want
I'd
to put it
like
on the record?
not necessarily.
No? Okay.
I mean, I'd like to, I mean, obviously I want to proceed because we have service and I think we've had contact with mom, although we're missing Jennifer, who did make contact with her. So I'd like to put something on the record that we've have her served, and I'd like to make sure we know where she is because she's has not necessarily been accessible. But
I'll text Jennifer.
Thank you.
And I'm covering Deborah. She has a family emergency right now. She just received her client's number yesterday and it was off. So she's asking for a short reset to get in contact with her. I believe she's going to be in agreement, but Ms. Fuller would like to have the opportunity to at least confer with her before this hearing.
And that's my understanding too. And I'm not one to oppose asking for a reset for a family emergency. So.
Well, and yeah, and this is a court order services rather than an emergency removal. So I think that's appropriate. Let me call it. We'll get it all on the record. Department of Family Protective Services versus Jailer Breonna Rice in the 454th Judicial District Court of Medina County, Texas. Court is streaming outside of Medina County from Kendall County via YouTube and Zoom. Any objection?
No objection.
No objection, Your Honor.
We are missing at this time the attorney ad litem, Ms. Harris. I'm sure she's probably going to join us at some point, but I just want to go ahead and allow the attorney for the mother, who's Mr. Saldivar, is covering for Ms. Fuller, and Ms. Kyler Green the opportunity to put their announcements on the record. Ms. Kyler Green.
Emily Kyler Green, attorney for the department, ready.
Richard Saldivar covering for Deborah Fuller for the mother. Not ready, Judge. She's had no contact. She received information yesterday and the phone was off. She'd like an opportunity to confer with her client, so she's asking for a short reset.
Ms. Flores.
Desiree Flores, and I'm the FBSS supervisor, just observing, Judge.
Okay. Ms. Vanderbilt.
Alexandra Vanderbilt, investigation supervisor, Your Honor.
Okay. I'm not going to worry about swearing anybody at this point in time, since it looks like this is just going to be procedural. Ms. Kyler Green, it's my understanding that Mr. Saldivar, on behalf of Ms. Fuller, is asking for a reset. Any objection?
Your Honor, the department is ready and feels very strongly that these services need to get started, but with the understanding that it is that there has been some contact made through the mother, with the mother through the child's attorney. I think that there will be an opportunity for all parties to confer and come to an agreement for court order services. So I think it actually behooves us all to have this reset.
Okay. Anything else you want to add, Mr. Saldivar?
No, not at this time, Judge. I think that's all.
Ms. Greenlee, have you by any chance heard from Ms. Harris?
I sent her a text message and I haven't heard back from her.
Okay. Well, if you just let her know, I'm going to go ahead and reset. I'll grant the request to reset to May 8th, 2024 at 10:30. It's May 8th, 2024 at 10:30. And any orders, well, I don't think we have any orders in effect at this point in time, but we'll take judicial notice that the mother was served. What day did you say she was served on that return, Ms. Skyler Green?
April 17th.
April 17th. So I'll take judicial notice the mother was served April 17th. And on that reset order, I think it would be prudent to add that I'm ordering Ms. Rice to appear on May 8th, 2024 at 10:30.
Yes, sir.
For that hearing. Zoom. Okay. Thank you all for your time and your service. McCaskill, would you please begin the announcements?
Yes, Judge. Straight McCaskill, attorney for the department. Oh, sorry.
I'm Carol McKenna, the family-based supervisor. Laura.
I'm Laura Miller, the family-based caseworker.
Irene Acosta, I'm appearing for Richard Saldivar, who represents the respondent mother.
Marco Cabrera, I represent the father, Mr. Cody Scribner. He's present, Mr. Scribner. Can you state your name?
Cody Scribner, here, Your Honor.
Maureen Yanis, attorney ad litem for the children.
Mr. McCaskill, have you had an opportunity to confer?
I haven't, Judge, but I know that a family plan of service has been filed, so I do believe there is an agreement for services.
Okay. Do you want to talk to the other attorneys briefly with your client?
We can, Judge. Sorry, we were occupied all day yesterday, so I couldn't really reach out.
I remember. All right, so I'll put would it be Miss McKenna or would it be Miss Miller? Or both?
Either or, Judge. I mean, I think I can just meet with the attorneys. Like I said, the family plan
Okay.
has been filed, so I know what their position is.
Okay. Mr. McCaskill, are you ready to proceed?
Yes, sir.
All right. What will be the agreement today?
Yes, Judge. So for Miss Smith, she will complete the Parents as Teachers program through SURC Texas, attend individual counseling, submit to request for random drug screens, and then follow up with her primary care physician about any potential underlying medical conditions that may have caused the concern that led to the intake the department received. And then for Mr. Scribner, he will complete the Parents as Teachers program through SURC Texas, and then continued compliance through with all of his probation services through Kendall County. And then for both parents, as far as Carson's concerned, the parents will contact the school for a developmental and speech delay assessment.
Is that the entire agreement?
Yes, Judge.
Mr. Cabrera, is that your understanding of the agreement?
Yes, Your Honor, it is. And we are in agreement to those terms.
Ms. Giannis?
Yes, Judge.
And then Ms. Acosta?
It is, Your Honor. Mr. Saldivar did want me to also mention that the mother is not conceding or admitting to any of the allegations, and that she's willing to work services, and she'd like to work to get the kids back in her care as soon as possible.
Where are the kids right now?
Judge, there was a safety plan that was approved on 3/26, and I don't know that anyone has received a copy of that. But the grandparents, my understanding, and Ms. Miller, correct me if I'm wrong, is that the grandparents, paternal and maternal, are assisting in supervising contact with the parents.
Yes, so paternal grandparents are they're currently staying with father at their house. And then maternal aunt, maternal grandmother are also assisting in transporting.
Okay. Ms. Miller, do you believe that's in the best interest of the children?
I do for now, Judge, yes.
All right. And you've heard the agreement that was announced today, and your understanding of that agreement is that it's in the best interest of the children as well?
Yes, Your Honor.
All right. And do you believe that this TFF case is necessary because abuse or neglect occurred, or there's a substantial risk of abuse or neglect or continuing danger to the child's physical health or safety caused by an act or failure to act of the parent in this case?
Yes, Your Honor.
Do you believe these orders are necessary to address any concerns of abuse or neglect?
Yes, Your Honor.
Do you believe family preservation services are necessary to ensure the children's physical health and safety?
Yes, I do.
All right. Mr. Scribner, can you unmute for me, please?
Yes, sir.
You heard the agreement announced by Mr. McCaskill?
Yes, sir, I did.
Did you have the opportunity to discuss that agreement with your attorney?
Yes, sir.
Do you understand what's expected of you out of the agreement?
Yes, sir, I do.
All right. And did you enter into this agreement voluntarily?
Yes, sir.
Were you forced in any way to agree to this?
No.
Are you asking the court to approve this agreement today?
Yes, sir, I am.
Thank you, Mr. Scribner. Ms. Smith, I understand that as part of the agreement, you're not admitting to the allegations, but you heard the agreement, correct?
Yes, Your Honor.
Is this the agreement you made?
Yes, Your Honor.
Did you have the opportunity to discuss it with your attorney?
Yes, Your Honor.
Do you understand what's expected of you?
Yes.
Were you forced into this agreement or given any promises or inducements to get you to agree to it?
No, Your Honor.
Are you asking the court to approve your agreement today?
Yes, Your Honor.
Thank you, Ms. Smith. All right. Then based on the announcements and arguments of counsel and the testimony, court will find first that both Mr. Scribner and Ms. Smith were served on April 17th and April 16th, respectively, by personal service. Court finds that there's sufficient evidence to satisfy a person of ordinary prudence and caution that abuse or neglect occurred, or there's a substantial risk of abuse or neglect or continuing danger to the child's physical health or safety caused by an act or failure to act of the parent. Family preservation services are necessary to ensure the child's physical health or safety, and family preservation services are appropriate based on the child's safety risk assessment and the child's family assessment. And the court will make orders that require specific services narrowly tailored to address the factors that make the child a candidate for foster care. And that includes parents as teachers program for both parents. Mom must also submit to individual counseling, random drug screens, and follow up with her primary care practitioner about any underlying medical conditions that led to the concerns that brought the children into care. And in addition to completing parents as teachers, Mr. Scribner will continue his compliance with his Kendall County probation services. Parents will also contact the school for Riley and make sure that that speech delay assessment is addressed. Our next hearing will be a court order services TFF compliance date of June 20th, 2024 at 10:30. June 20th, 2024 at 10:30. Mr. Scribner, at this time, well, I'll ask both of you at the same time. Do either one of you have the money to pay for an attorney in this case?
Yes, sir, I do.
You do?
I do.
So basically what that means is if you have the funds to pay for an attorney, then the court will remove the indigency finding made in a preliminary basis in this case, and you will have to hire an attorney. You don't have to have an attorney, but if you want one, you'll have to hire an attorney if I remove your indigency status. I'm going to ask you a few more questions just to make sure that you are in fact not indigent. Do you currently have a job?
Yes, sir, I do.
Do you work full-time?
Yes, sir, I do.
Do you pay your own mortgage or rent?
I pay some of it. My parents help me out with it.
Okay. Do you have a car payment, credit cards, things like that?
I don't have a car payment, just mortgage.
Okay. At the end of the month, when you paid all your bills, do you have enough money left over to pay for an attorney to represent you in this case?
Probably not. You know what? I'll stick with the court appointed.
Okay. Do you receive any type of government assistance?
No, I don't.
And you're currently paying probation fees and things of that nature?
Yes, sir.
All right. Ms. Smith, I'm going to ask you the same question. Do you have the ability at this point in time to pay for an attorney out of pocket for this case? You're muted.
No, Your Honor.
All right. Do you have anything that, or I'm asking you both this question. Do either one of you have anything that you could part with or sell, or any money in savings that you could liquidate to pay for an attorney?
No, sir.
No, Your Honor.
All right. Ms. Smith, are you receiving any type of governmental assistance?
I was receiving food stamps and I am receiving child support.
All right. I'll find that they're both indigent for the purpose of this case and maintain Mr. Cabrera and Mr. Saldivar in their appointments. Mr. McCaskill, anything I failed to address?
No, Your Honor.
All right, Mr. Scribner and Ms. Smith, there's one more thing I want to tell you. This is the least invasive way to get services through the state of Texas when it comes to your children. If you don't comply with these services and you don't do what you've been ordered to do today, then it's going to get more invasive and it's going to get more difficult, and it's going to start invading the time you have with your children and how much access you have to your children. Okay?
Yes, sir. Understand.
In a big way, in a legal way. Nobody here wants to see that happen. So please take advantage of these services. Please get the help you need. Don't just check the box. Engage in these services and use them in your parenting. And the faster you do that and the more intentionally you do that, the faster this case will go. Okay?
Sounds good, sir. Thank you.
All right. Thank you both. Thank you all for your time and your service. If nothing further, all parties are excused.
Thank you.
Hey, Judge, Irene and myself are back. Our clients should be coming back. And you can, if we can go back into room 1 with Mr. McKeska and just let him know we have an agreement.
Judge, we're back and ready whenever you are.
Department of Family Protective Services versus Brandy Stevens and Stevens-Hale in the 216 Judicial District Court of Kerr County, Texas. Court is Zooming and YouTubing from Kendall County, Texas. Are there any objections?
No objection, Judge.
Mr. McKeska, would you please begin the announcements? And if the attorneys would please prompt their clients to announce.
Thank you, Judge. Drake McKeska, attorney for the department. Mr. Williams.
Dustin Williams, interpretation investigator.
Jimmy Drosden Mitchell, investigation supervisor.
Cynthia Rabago, family-based caseworker.
Listen to Mance for the children. I'm ready.
Irene Acosta for the respondent father.
Kathleen Savage for the respondent mother. Ms. Stevens, we're ready, Your Honor. Ms. Stevens, if you can announce your name for the record.
Oh, Brandy Stevens. Hi.
Anyone who's not an attorney or will be giving testimony, which includes both parents, please raise your right hand. Do each of you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
Thank you. You can put your hands down. Mr. McKeska, the agreement.
Yes, Judge. So the family plan of service has already been completed and filed with the court. And the services for both parents are the same judge. So I'll just do them together. So the parents will complete the Parents as Teachers program with SGRC Texas, complete a drug and alcohol assessment, and follow any and all recommendations from that assessment, submit to random alcohol and drug testing at the request of the department, and then participate in individual and or family counseling. And that is it.
Family and individual counseling?
It says the family plan judge says and or they're both parents are being referred to Joni Chavez Martel. So I think it's really up to the parents what they need and what Martel or what Ms. Chavez Martel believes they need as well.
Ms. Savage, is that your understanding of the agreement?
Yes, Your Honor. But it was our understanding that the concern was alcohol use. So we would just be asking that any drug testing or alcohol testing be limited to the alcohol, since that's the concern. There's no issues or concerns with illicit drugs unless recommended otherwise by the OSAR.
Response, Mr. McKeska.
I just going to check with Ms. Rabago, but if she can just let us know.
Yeah, since the concern has only been alcohol and there's no issues with any other substances, it can be just alcohol testing.
Otherwise, good to go, Ms. Savage.
Yes, Your Honor.
Ms. Acosta.
Yes, Your Honor, and I did have the same concerns as Ms. Savage, but those have been addressed.
Ms. Mance.
Yes, Judge, I'm in agreement.
Mr. Hale and Ms. Stevens, I'm going to ask you at the same time. You can both answer at the same time. Is this your understanding of the agreement?
Yes,
Your Honor.
Did you both have the opportunity to discuss it with your attorney?
Yes,
Your Honor.
Do you both understand what's expected of you?
Yes, Your Honor.
Were you forced to enter into this agreement in any way?
No, Your Honor.
Were you made any promises or given any inducements to get you to agree to it?
No, Your Honor.
Are you asking the court to approve your agreement?
Yes, Your Honor.
Thank you. Mr. Bago, do you believe that abuse or neglect occurred or there's a substantial risk of abuse or neglect or continuing danger to the physical health or safety of the children caused by an act or failure to act of the parent?
Yes, Judge.
Do you believe that family preservation services are necessary to ensure the child's physical health or safety?
Yes, Judge.
Do you believe that the services that have been stated here today are appropriate based on the safety risk assessment and the child's family assessment?
Yes.
All right. You believe these services are narrowly tailored?
Yes.
Thank you. Court will find that both parents were served, take judicial notice of their returns of service in the file. Mr. Hale was served April 15th. Ms. Stevens served April 12th, both by personal service. Court finds they have also appeared here today and through counsel. Court will adopt and approve the agreement of the parties. Court takes judicial notice that the plan is already filed with the court, that the parents will complete the Parents as Teacher program with SJRC, along that they will submit to, you said drug and alcohol assessment, but I mean, that's a title as far as the assessment goes, correct?
Correct. Yes, sir.
All right. Parents will complete the drug and alcohol assessment and follow any and all recommendations. Parents will submit to random alcohol testing only, and parents will submit to family and or individual counseling based on recommendations of Ms. Joni Chavez Martel, their counselor, or any other counselor that might be involved in this case. Court will make the findings that abuse or neglect occurred, or excuse me, there's sufficient evidence to satisfy a person of ordinary prudence and caution that abuse or neglect occurred, or there is a substantial risk of abuse or neglect or continuing danger to the child's physical health or safety caused by an act or failure to act of the parent. Family preservation services are necessary to ensure the child's physical health or safety. Family preservation services are appropriate based on the child's safety risk assessment and the child's family assessment, and the court's order based on the agreement of the parties is narrowly tailored to address the concerns. We're going to be back for a compliance hearing on June 5th, 2024 at 2 p.m. June 5th, 2024 at 2 p.m. Mr. Hale and Ms. Stevens, I want to make sure you understand. This is the least restrictive way that the state of Texas can get involved in your life with your children without starting to change legal designations and bringing everybody into court and removing the children and putting them in foster care. Okay, this is the first step. And so strongly encourage you to follow my orders and to do the work that it takes to get these things done, engage in these services and use them. If you do that, the faster you do it, quicker we get through this case. I'm not telling you to check a box. I'm telling you to engage in the services. So you got to start now, because some of these things you can't do in 1 week. You can't do in 2 weeks. You can't wait till the end to try to do it. It won't work. You got to start now. Nobody in this room wants to see this get any more intensive or invasive on your life. Okay. Mr. McKeska, is there anything I failed to address?
No, Judge.
Okay. Thank you all for your time and your service. I appreciate you working out agreement. Good luck to you both parents. And if nothing further, all parties are excused. That concludes our docket for today. I'll see some of you tomorrow. Everybody have a